Good morning, and thank you very much for joining us. I am Yori Folarin. Okay, it's politics, but it also has this whole legal implication. Talking about the amended charges, preferred against Senate President Bukola Saraki. The whole matter has now been shifted to March 23rd, and the Senate President will need to take a fresh plea. I guess that means he has to say whether guilty or not guilty. Okay, my guest this morning, we got Barrister Malaki Ugumadu, National President, CDHR. Thank you very much for coming on, Barrister, because we want to know what the circumstances are under which people amend charges. And Dr. Amadili Boyo, he's a medical practitioner, but he's also a public affairs analyst, keeping a very, very keen eye on the polity. Thanks, Amadili, for coming on.
Thank you very much.
Barrister Ugumadu, what happened? Why do charges get amended?
Well, if the body of evidence available to the prosecution has changed, and if they have come across certain facts and pieces of evidence that were not available to them at inception, they are at liberty. What I mean by that is
the prosecution?
Yes, prosecution. What I mean by that is that the prosecution is well within its prosecutorial powers to amend the charges preferred against an accused person even after he has concluded his case.
Oh, okay. So this effectively resets the case, so to speak.
Certainly so, to the extent...
It defaults back to the beginning.
To the extent that the accused person will have to be proven guilty beyond every reasonable doubt with respect to each count of the charge. And therefore, if for any reason the amendment occurs in the process of trial, then that same accused person will be arraigned again. Arraignment includes the reading of the charge to him, the request that he pleads either guilty or not guilty, and then the assurance that he understood the content of that charge to the satisfaction of the judge, and in the failure of which he will be given an interpreter who reduces the content of the charge in a language that he understands.
So that's where we're at now, because of this news, and it's now been deferred to the 23rd. But before we proceed, we started, when the story came up yesterday, we started putting it out. Let's take that story by way of background.
The Senate President arriving for his trial, unaware of what awaits him. After exchanging the usual greetings with his lawyers and supporters, it was time to get down to the business of the day. The 18-count amended charge was drawn to the attention of the Code of Conduct Tribunal Chairman, Umar Danladi, by the lead counsel to Saraki, Kanu Agabi SAN. Midway into the examination of the third witness, Samuel Madejumi, on the old charge, Agabi rose up and informed the tribunal that an amended charge has been brought against his client and that a copy of the charge has been delivered to him by the lead prosecution counsel, Rotimi Jacobs. Agabi claimed that the action of the prosecution, continuing the call of witnesses and conducting the trial, was in bad faith when a fresh charge has been filed at the tribunal. Agabi demanded suspension of the trial on the grounds that the fresh amended charge takes precedence over the old charge. Jacobs, while confirming the filing of further amended charge, on the other hand, that he allowed the trial of the old charge to continue since the tribunal has already fixed Wednesday for continuation of trial. Agabi subsequently applied for an adjournment to enable his client and the legal team time to study the new charge and prepare the defense along with the new charge. In his ruling, the tribunal chairman agreed that the defense needed time to study the amended charge and subsequently adjourned to the 23rd of February for rearrangement and continuation of trial. A counsel to Saraki described the rearrangement as political.
The prosecution brought fresh charges. We had no notice of this. We came prepared to continue with the hearing, as you know. And halfway through the witnesses' evidence, we became aware of the fact that fresh charges had been filed without prior notice. And a cursory glance at the charges and the new bent of the witnesses' evidence showed that there had been substantial changes to the charges that had just been filed. Some of the charges that had been problematic to them, the ones that showed that they had probably tampered with the defendant's forms, they've surreptitiously removed them to make that argument supposedly difficult to make anymore. But it doesn't change the fact that the exhibits remain the same. But it's very clear that the defendant's case is very, very good. The world knows that the Senate President did not declare any false assets, and that this case, as I've always said, is political.
But the counsel to the federal government sees it differently.
We tender several exhibits through webcasts, and that we discover so many pieces of evidence that we advance the case of the prosecution. So in line with the evidence that we got, we need to bring those facts in line with the charge. So that's why we amended it. And they shouldn't even make an heavyweight out of it. We are not introducing anything new. It's just to simplify it and make the court get what the charge, the allegation in the charge, and the evidence before the court. It shouldn't be a big. It can even be done even after the closure of prosecution's case, or even during the defense.
Okay, so that's the report that went out then, and there we have it. The lawyers can't seem to agree. On the one hand, the defense is saying that substantial charges were surreptitiously slipped in, but then for the prosecution is saying nothing like that, as Malaki explained at the top, additional information was found and this had to be made. But I suppose, staying with you simply because you're the expert here, why did it take the defense, having arrived for a to continue the hearing, notice it and then bring it up? Shouldn't one party have told the other party that things have changed as we go to the next date?
I think this is a very important question to ask, because certainly it creates the impression as if surprises are allowed in legal practices, whether civil or criminal. In short, much more important in criminal matters. You don't spring surprises. If you do, it invokes the right of the defense, that's the accused person, through his lawyer, his or her lawyer, to raise that. What I imagine we are here analyzing, in summary, what probably must have happened, because we're also not allowed to go into the merits of the matter. But what I imagine must have happened is that the fact of the amendment through the amended charge must have been filed and brought to the notice of the court, and then same made available to the accused person. The court cannot even rule on it if it is not before it. That presupposes that it must have been charged. It must have been filed. I'm talking about the amended charge, and it must have entered the records of the court and subsequently served on the defendants. The principle of fair hearing under Section 36 of our Constitution seriously frowns at circumstances in which you can spring surprises, particularly on criminal matters, because the standard of proof is beyond every reasonable doubt.
Okay,
and this given adequate
and this certainly is a criminal matter
yes,
that Senate President Bukola Saraki is facing.
That's right.
So all those rigorous standards must apply. Amadili, what do you make of this?
Yeah, if you listen very well, the Samuel Madujemo, the Chief Administrative Officer of the 60 Code of Conduct Bureau, was the principal witness 3, prosecution witness 3. And what he had to say was that they discovered some discrepancies, and that the discrepancies discovered had to do with false declaration and non-declaration of some assets and some liabilities. So when the lawyer was asked, as the lawyer for the prosecution lawyer was asked why he had to do this, he said it's not a fresh thing. It's just new wine, additional wine in old wine bottles. And so the case could go on. And he went on to say that though they were pursuing a particular direction before, they found out more in fact, this Chief Administrative Officer was able to say that in the process of investigation, they found out more information that they had to add to it. And like some other lawyers will say, I'm not a lawyer, that if you find out that your case is going to be tighter with some additional information, it's like somebody, a lawyer said, even the courtroom process is a war. It's like a war, or like it needs strategies and tactics. When you find out that the way you are going, they could pull the rug under your feet, and you have additional information, you come up with those ones. And it's not foul. The important thing, like has been said, is that everybody should be made aware of the information before coming to the court.
Okay, indeed, so that no surprises are allowed. Okay, our correspondent Sumner Sambo, you know, he's standing by to join us and also shed a bit more light on this. Sumner has been covering this particular case from the very, very beginning. Morning, Sumner.
Good morning, Yori.
So, what is the thinking now? Is it, when you just look at the thinking between the two parties, is it that this is a tighter case, a more difficult case now, or just what's the thinking going on?
Well, the prosecution witness has been given his account. That's the third prosecution witness. Samuel Madejumi is his name, and he's the lead head of investigation at the Code of Conduct Bureau. He was given his own account of all that he knows when the prosecution counsel stood up to say that he had filed some amended charges from 16 to 18, and he had given it to the defense counsel. And from all of this, we now had a situation whereby the prosecution counsel was trying to push forward a situation whereby the defense counsel feels that the trial shouldn't have been going on if indeed there had been some amendment to the charges. And of course, he sought for an amendment, and the amendment was given to 23rd of February. Now, this does not in any way jeopardize the trial, but what has now happened is that it has now given room for the defense team to properly look at the new charges filed and see how they could defend Senator Bukola Saraki. But one key thing that the lead prosecution counsel said yesterday is that these two additional charges are not really new in that sense. He said these two additional charges are a summary of some of the 16 count charges that were earlier filed. Don't forget, the federal government started with 13 count charges in 2015. Then it was amended to 16 in 2016, and now it is being amended to 18. So we are all hoping that the defense will be able to use this opportunity to sieve out whatever is new and then see how they can push their case forward to protect their client.
I suppose it's in the natural course of the way lawyers do things. The lawyer for the defense was referring to the amendment as significant changes, and as you've just told us, the prosecution is saying that it's not very radically different. It's just that we have to tidy it up. But that the defense is seeing it as very, very significant. Well, I think we lost Sumner, but thank you very, very much, Sumner. We can take it up from here now.
So you see, when
sorry, we got to go to a quick break, and then let's come back and really have the time we need. Stay with us, please. Okay, welcome back. And I had to interrupt Madili just before we went on break, so now we can have it.
Yes, I was saying that the Madejumi, the chief investigating officer from the Code of Conduct Bureau, also posted that the issues here are about the property that the then Governor Saraki declared on McDonald Avenue in Ikoyi. Namely, the initial charge was that Saraki had declared numbers 17A and 17B McDonald. But further investigation by the Code of Conduct Tribunal got 15A and 15B. So these fresh charges are included in the
15A and 15B in addition or in replacement for what was an error? In addition
to 17A and 17B.
Okay, I see.
Costing $265 million as at then, 2006, and they were not declared. So they want to increase that and they want to include that in the charge. This is in addition to other things. So I think if the prosecution discovers such thing and they want to prove it and they have proof of it, it's good enough. But like we said, the administration of justice should have been better served if the defense got these papers before even coming to court. And so the defense should not claim ignorance of the paper. They can ask for time to study and respond to. And I also wonder why we always take like 2 months, 3 months adjournment of cases in this country. Because studying this thing shouldn't take more than 2 weeks or 3 weeks. Because this thing is dragging. I'm talking of 2015, this is 2017.
Well, they say the wheels of justice grind slowly, and my brother is here.
Well,
but what, okay.
Yeah, please go ahead.
What this really shows, because all sorts of things going on, it's an important case, it's an important issue. Arguably, it was being swept aside in the public consciousness because of all other monumental things that have come on the scene since then. But this is proving that that might have been a perception, but work was going on in the judicial system on this whole matter. It was never anything but front burner.
Please, let me make a few clarifications. Perhaps it will guide the discussion. The one is that when this matter kicked off, rightly in 2015, there were preliminary issues that came up. Issues of the jurisdiction of the court, issues of the competence of the judge to preside over the matter, and a few others. All of these traveled away from the tribunal up to the appellate courts and came back. Now, in the administration of justice, no less criminal justice, you cannot dispense with the cardinal ingredient of fair hearing. Fair hearing is a fundamental right that inures to every Nigerian, inclusive of accused persons, since their presumption of innocence is already stated and protected. The implication of that is that I can even refuse to plea. If you want to arraign me and I'm able to discover defects clearly on the face of the charge you have brought, I will refuse to be arraigned.
You can do that?
Yes.
You can legally do that?
The defense can, in short, the defense can, upon looking at the charge, bring an application urging the court to quash that charge.
Okay, yes, one hears that.
Now, that will mean that you're not even going to be allowed, as your client, to enter a plea because the foundation for that is defective. All of those take not 1 week, not 2 weeks, in terms of, my lord, I have this preliminary application to make on the face of it, and we must be able to file our, being a court of record, it is not a court of summary trial like you have in magistrate courts and so on and so forth. So please, that is one leg of it. So if in the course of trial, preliminary activities have taken up to appellate courts and come back, I remember when, I think it was the Court of Appeal or even the Supreme Court that said, no, this matter can be tried by the... Now, on the issue of amendment, and please, I'll rest my case here. I have made the point, and I'm going to be very circumspect as I deal with this because it is sub judice, that charges can be amended at any time of trial. I have been in a matter in which I was in defense, where charges were amended 3 times. In short, it was at the instance, it was at our instance in terms of protest, because we were aware that there are many other people who ought to be involved, who ought to be charged along with our client. Charges were amended up to 3 times. Now, it is permissible. What you do as a defense team is to, like they have done, first they resisted the arraignment, which was partly what the prosecution wanted to do. It was within the powers of the defense to say, no, this is a criminal matter. This section 33 I cited talks about giving the accused person adequate time and facilities.
That's why it was, deferred to the 23rd of March. Our man, a slip of tongue, said 23rd of February, but he meant 23rd of March.
And when you're
giving them time to study the amendments.
You look at it. And when you look at it and find perhaps on the face of it that this cannot fly, you are also at liberty to bring one application on. Otherwise, it is in your interest of the state, because justice in criminal matter is not a one-way traffic. Justice in criminal matter goes to the state, which is the prosecution, goes to the victim, which is the entire Nigerian people whose resources are allegedly fleeced by the accused person, and then justice to the accused person.
Yes, yeah, exactly, to the accused person. Now, the other question that I think, whether it was somebody later brought it over, let me just take, yeah, he did in his last submission. It's about these things take forever. People probably, have a right to wonder when are we going to get a resolution of this case, one way or the other?
It has become very important to begin gradually to correct this. We are all victims. I mean, I have often made the point right on this studio that the notion of justice itself flies away. It disappears at the point where the public loses faith in the process. But we are all in the same shoes. We're all in the same country where it seems that these things are happening. It is no longer as endless as it used to be. We all remember the case of...
It's not good yet, but it's a lot better than it used to be.
God bless you. We all remember the case of Ojus Okalo. He never went to trial. We remember Chimaroke Namani. We remember a host of other cases that lasted more than 7 years, and, we never got
vanished.
Today, from the 13th of May 2015, you had the Administration of Criminal Justice Act, which regulates most of these criminal trials, and took away all of the bottlenecks that we have always had in the past in terms of speedy dispensation of justice.
Thank you very much, Malaki. Let me go to a quick break, and then I'll be right back, and we'll include your calls as well. Welcome back, and we're looking at the case of the Senate President, his criminal trial. It's taking some progress in the sense that now there are amended charges, and the whole matter has been deferred to the 23rd of March when he will have to make a fresh plea. Now, of February, not March. It's February, actually. Okay, sorry about that. So my error then. Sumner got it right. The newspaper in front of me got it wrong by saying March 23rd. So that's amended. It is the 23rd of February.
In short, the Administration of Criminal Justice Act, as it is now, enjoins courts to adjourn cases on daily basis. Yes. On daily basis, we're in court. We do see there could be mistakes, there could be lapses here and there, but the whole effort with the emergence of this Administration of Criminal Justice is to take away all the areas causing delay in the Administration of Criminal Justice, including, of course, that you cannot, in the lifespan of a particular criminal trial, ask for adjournment more than 5 times.
Okay, there's a 5-time cap,
yes,
5-time limit.
Yes.
Okay, now we've heard, they say that the wheels of justice grind slowly, and oftentimes it is explained like, look, if in the worst case scenario an innocent man has to go free simply because, let a guilty man go free rather than an innocent man be erroneously, convicted. That to one side, one understands the logic of that, but in these cases, because people have been complaining about impunity, at least we've gotten to the level where a charge has been brought, but it doesn't look like it's going to be much faster, as fast as the ordinary person will want this matter resolved.
Yes, if you listen to the lawyer of the defense team, one of the lawyers, that said this thing has some political cloud around it. That's
Yeah, he felt it had
politicized,
political connotation.
Yes, and that's when something has political connotation.
Oh, I don't know
you
what that
find out
means.
that what that means really is that the guy is the president of the Senate. And if you remember the whole hula baloo.
But the law
over-
doesn't know about
It's not a
president
law.
of
It's not a
anywhere.
law we're talking about. We're talking about public perception. That's what we're talking about.
No, we're talking
he
about
has
the-
explained that the adjournment is February, and that it's now the judicial act, the
Administration of
Administration of
Criminal
Justice Act has already given maximum of 5 adjournments, and they can go on every day. But this slowness we are talking about now, we've also seen that from 2015, it wasn't the fault of the court. The defendants appealed against the person trying the case, the judge, the chairman of the Court of Conduct Tribunal. They went up to a level of Supreme
Because
Court.
they've gone to great lengths to prevent this whole
From coming out.
trial from coming
taking
up.
place at all. They even questioned the Court of Conduct Tribunal. Remember, there was even the case of even the Senate trying to decide whether the Court of Conduct Tribunal can even go on. They were even bringing up the act setting up the Code of Conduct Tribunal again. So this case in itself is not justice that is being questioned. I think it's the perception of justice that makes people to feel that the case is dragging, because we have seen that this case has been going through what we call an acceptable a route that has been planned out because of the appellate system that came in.
Yeah, but when in the past, some cases, as Malaki noted, and we don't even need to be lawyer to look at the papers and know that, some cases in the Supreme Court go on for 20 years. But he even spoke about 7.
Yeah.
That is not unusual. And in this dispensation, you see, those are the things that have to change within the law.
Yeah.
I mean, one
But
can't
whatever it
summarize.
is, once a political figure is involved, like I said, we need to understand that this issue, Bukola Saraki feels persecuted because of the way he came about as a president of the Senate. He felt that the ruling party, APC, could not have its way, and he ganged up. He got the PDP and Lapo to support the Senate president. In the mind of Bukola Saraki and his cohorts, it's as if this is a political persecution. So what we can see here is that what appears to be dragging here is from the perception of the public, because the Code of Conduct Tribunal appears to be doing very well in terms of the speed it's taking.
Okay, let me reach out to Suleiman calling in from Abuja. Good morning, sir. And I think that was the sound of losing him. That was the sound of losing him. Suleiman, see if you can get us back.
So
there's
a political aspect to the case. I'm not talking about
from
the public perception.
Thank you.
Yeah.
From the public perception. I'm not saying that the judge is political. I'm not saying that the criminal justice system is political. I'm saying from the
that it is
perception
a political case.
No, I'm saying the perception of the public is that this man, when government they attack, now because of this and that. Yes.
Especially with all the senators accompanying him.
Oh, yes. In fact, Senate closed down in the beginning of this case, in 2015. Nobody will go to the Senate. Yes.
Malaki, you wanted to add something?
Well, I am driven by the conviction that the focus of the discourse must always remain within the context of what the issues are. And what do I mean by that? Section 15, subsection 5 of the Constitution that we operate today clearly states that the Nigerian state shall abolish all forms of corruption and abuse of power. If you go to the 5th schedule of the same Constitution, it creates the Code of Conduct Bureau and Tribunal, and then enumerates in subsequent sections what constitutes offenses under the Bureau, particularly relating to public officers. So in a sense, yes, we have been bashed from all ends, but if a government in which the Senate president, also a member of the same political party, has managed, as it were, to navigate all the curves and come up with a charge, at least not frivolous, because it has gained the trial processes in court, then we need to begin to build on things like that incrementally. Because my fear...
because I got to... I'll come back to you so you can continue, but
yes.
Because I have a caller who's been waiting for a while. And thank you very much for that, Mr. George. Good morning. Good morning, Mr. George.
Good morning, Uncle Yori.
Thank you very much for holding on.
Thank you. Mamaki, good morning, and good morning to Dr. Boyo.
Good morning.
Good morning.
Uncle Yori, I want to ask Mr. Mawaki this question first. There is this ACTA law, the Administration of Criminal Justice Act, which says cases should be tried on a day-to-day basis, and that there should be no adjournment for more than 2 weeks at a time. Why is it that the court and the legal system are not obeying that law? That is number one. Number two, Uncle Yori, this is why I didn't join the prayer of those who were converting for the confirmation of Justice Onongen as the ES. I looked at the period they have acted as the Chief Justice of this country, and I didn't see anything he has done differently to facilitate the justice system, to address corruption in the judiciary. I did not see anything he has done differently from those who have been there that brought this country to our knees today. So apart from ethnic purposes, what is the reason why people are saying it is this man that should be there, it must be Justice Onongen that must be there? I want someone that can bring changes to our justice system that will all be proud of. And I don't see it in this gentleman. This is my view, Uncle Yori.
All right. Then. Good morning, Mr. George. Very
Well,
interesting.
yes,
Well,
a brief comment.
Can I just
he directed
that's a
the
brief
questions to...
okay, I directed questions to Malaki.
So that the public will be guided in...
I'm sorry, Dr.
Boye, yes.
Could you just let me...
No. It's not, I just wanted to say the aspect of, in this case, with those 2 weeks adjournment.
Yes.
And so it falls within what he was trying
The
to say.
23rd?
Yes, yes.
Okay.
Yes. No.
So he made the point regarding...
Why are courts not following that 2-week time limit?
No, before then he talks about the day-to-day adjournments.
Yes.
My statement before he called was on that, namely that with the coming into effect of the Administration of Criminal Justice Act 2015, indeed it came into effect on the 13th of May 2015, courts are enjoined by the express provisions of this law in criminal matters to deal expeditiously on day-to-day basis with matters that comes to them. And we've witnessed that as practicing lawyers. I mean, it will take a while. Perhaps if you begin to record convictions in the 2 years administration of this, people will begin to gradually understand that these things are already happening. So that is on the one hand. On the other side is the question of the appointment of... well, I know it is not exactly what we are discussing.
Yes, and you were helping, telling us to, be guided by the substance of the
discussion. So I refrain from that.
We just take that. That was his comment. You heard his comment.
Yes, but I also want to say something, that when you are in an acting capacity, there's very little you can do. And you try to be as cautious as possible because you are acting. Your confirmation, your appointment has not been confirmed. You cannot judge somebody by what he did in an acting capacity because you try to be very, very, very cautious. And so that's just my comment on that. We don't want to face what is on the table, so that we don't get distracted.
Very interesting comment. Talking about acting and no acting, and when you're acting, there's very little you can do.
No, I didn't say there's very little you can do. I say you try to be you try to be very, very careful.
As circumspect as
that's the word, as circumspect as possible. Because don't forget, there's so much surrounding even the confirmation hearing, so much surrounding what is going on. And even if you want to do things that you can sustain and you can explain. You don't come in like a bull in a china shop just because you were made an acting Chief Justice. And people begin to feel that this might don't take the look for this position. They never get and say, we don't cause trouble. Are you getting me? You have to be very, and again, the position of a Chief Justice.
I can see Malaki nodding his head.
Position of a Chief Justice.
A lot of this is on, is on point.
Yeah.
Well, it comes in two forms.
Yeah.
Very valid point he has made. But there are also others who will even dramatize capacity in acting capacity. I talk of the EFCC chairman, Ibrahim Magu. He had visited my organization, and while in my office, I asked him one difficult question, namely, how long do you think you have in this your new office before you are chased away like your predecessors? And what he told me that day was instructive, and I think it's been playing out, that even if his tenure ends after our meeting that day, but that he was going to act as though that meeting will not end. That is precisely what we have seen. How many judges are on trial? How many EFCC prosecution lawyers in the category of senior advocates are on trial? How many public officers whose cases were already abandoned have been reopened? How many fresh cases have been introduced in the face of the very limited funding that they deliberately have been given, And I would think that what is important is you cannot cease to be a Yori, even if you leave this studio. I would continually respond to those ingredients that constitute the values that I hold dearly. Indeed. Which is why some of us are pained that rather than ostracizing some of these ex-convicts that we have, I was in Delta State painfully when one of them came back. You now have, celebrations everywhere.
Terrible.
Just as you had for Olabode George.
Well, let me thank you very much, Mr. Yakub, for holding on. Please go ahead now.
Yeah, good morning, sir.
Thank you for calling. Good morning.
Good morning to Mr. Malak and Mr. Moni.
Good morning.
God bless you all, sir. You see, Shijori, I want to make a response this morning by saying that you now see the reason why Nigerians sitting at clamoring for Senate President to just leave that position and face the charges. Especially whereby they charge him to court, and then in the case of him adjourn the case, they will be looking at if we adjourn this, we are fine because we are telling us about a criminal act that they amended now. If we say that it should be coming to court every day by day, it is not going to affect the responsibility of Senate President in the House. That is the reason why. It is only this country this kind of a thing can happen. This is a criminal case.
Okay, Yakub, I'm sorry to rush you, but thank you very much, Yakub. I've got to rush off to a break right now. Thank you very much for calling. Stay with us, please. Okay, welcome back. Of course, depending on where you are at in the polity, in relation to the office of the Senate President, broadly speaking, there are all these camps when people talk about politics, but you can sort of distill the essence of it, and it's been explained again and again that it's not a political case, it's a criminal case, and we're going to have to find if it's guilty or not guilty, and that's where we're at now. But it is a problem still because, as you were saying, Ahmadili, you said, as far as you could tell, the Saraki camp has the sort of body position of they're out to get me.
Yeah, because
of the circumstances.
Yes, everybody wants to play the victim. And when you play the victim, it's public opinion begins to go in your direction. And politics is about public opinion.
But the out to get me as a conjecture is on the one hand. The other thing is that the fact of the matter is that, is it a good charge or not?
Yeah,
when you have your chance in court
when
to
you're
come
dealing
and give your opinion.
in a developing country like Nigeria,
yes,
where people level of illiteracy is very high, and people are very passionate, and people are very, very biased. People, all kinds of things coming. People will want to say, leave this man alone. And if you remember, anytime
and we've been complaining about impunity.
Anytime the president of the Senate goes to Aso Rock, people think they are trying to mend fences. There are people that believe that if Buhari can mend fences with him, they will not, this case will drop. Not knowing that the will of justice will continue. You are allowed to grant. That's what Yaradua talked about, due process, and talk about legal. I've forgotten one of the mantra of Yaradua administration was
But those kind of things have been known to happen in the past. But let me take somebody who has been asked of, you know, in recent times. Comrade Okoro Afo, good morning.
Good morning, sir. That's Comrade Patrick Okoro from RTJ.
There you go.
Mr. Yori, good morning. I want to find out from our guests in the studio.
Yes.
All these fresh charges and fresh cases we are having now, where have Nigeria dropped such cases? And why I think this? Because there is nothing happening in Nigeria without no smoke without fire in this country. Now, immunity, whether spiritual immunity in Nigeria is being existed. So at the end of the day, what we are saying in Nigeria is just a Rambo show. At the end of the day, everything will appear on television, everything will just watch them, and the business continues. Now, Nigeria, if we have that system, we have that operating in China. And I think all this issue of eating and not eating will not come up. Nigeria, we have passed that level of being to that. But the thing is that we are a country that come, chop will go. It is our turn. That is different. Because we have not called a trade in Spain. Press service or no press service, what are we doing? Where are we heading to? Let us call it spade in this country. Nigeria, I don't know. Thank God, thank God. Thank you very much, Mr. Yori, and our guests in the studio.
Thank you very much for calling in. We've had the issue, it's a long-standing issue of impunity. Arguably, this administration, before arriving, had said that they were going to change a lot of things. And no doubt, this is something that they would want to put behind us in our national life. This is what is going on. But again, it's going to be open to political speculation, simply because this is the only thing we've known. I like the fact that...
I think you have, hit the nail on its head. You have properly characterized it. We were already dealing with the problem of impunity. Impunity is the advanced form of the transgression itself. In other words, we are no longer dealing with the malfeasance. We were dealing with impunity with which they were committed. I would do this, nothing will happen. And it was precisely that way for as long as 17 years, almost 2 decades. At that point, it goes into the psyche of an average person who refuses to be rigorous, that there can be any change, regardless of whether a Trump has come to town or whatever. What then is the issue? Imagine it, flip the coin and imagine a situation in which maybe, and maybe not, a Saraki is convicted in this country, the president of the Senate of the Federal Republic of Nigeria. That will change the narrative. Let's even imagine that it was Ojoso Kalu, who immediately after joining APC got his fingers burnt because his case was reopened. Let's imagine that a conviction can be secured. I'm not praying that it should, but assuming it happens. If the Senate president, who is a member, a high-ranking member of the ruling political party, secures conviction through due process of the law, I can assure you that the perception we talk about will change.
Indeed.
The narrative will also change.
Idibore, calling in from Taraba State. Good morning, sir.
Good morning, sir. I want to contribute in this program.
We're waiting for you.
Yeah. You know, what you people are discussing there is very good. But we should look into all those things in the politics of Nigeria. As we have been talking about Saraki, you know, I'm not a member of party, but what makes me to be impressed with this government is that they came to do the fair. And if all those things that they were in the past government, that they want to come and correct it, see, those things they have been doing the same thing. Why saying this? As Saraki was in the government then, there is no CCT in Nigeria. That is question number one. And why then CCT does not drop all those things, allegations on him? If it is true, we have been doing a Greek politics. And now, when he came to the power, that he has elected as the Senate president, he brought with some allegations. And up to now, they have never tired. They have started the case again. And then they brought another new one. All these things we are there. And they didn't solve this thing. And now they're seeing. So, you know, all this way we have been going with the politics in this country. it will not give us a result because we think that we have been doing enmity, not that we have been ruling country. We came to make our country proud, but the way governments have been running in this country is as if it's enmity that they have been playing. That's why you see all the people have been complaining and saying a lot of things. Because if you say that those people are doing wrong things, you see and you know that those things are wrong, you came to correct them. You have to correct them, not just and don't just do same thing that what those one guys did. That's why you two have been doing that, or you did this because them too they do that. If you see the comments of the president now that he went outside, people are saying before.
Okay then. Well, thank you very much for your call. Really appreciate your call. What could you make of that opinion?
Yes, I think he was trying to say that all these things is being politicized. And that this trial of the president of the Senate is being politicized, and that the ruling party cannot claim to be innocent, and that there are people that are still committing crimes within the states or areas where the current party rules, and they're not being told. And this is an attempt to just deal with the man for whatever reason. That's what I think. I may be wrong, but that's what I think. But at the end of the day, what our friend, our lawyer friend here said, it's just about impunity. And if the perception is not corrected, and people are made to realize you can't get away with things in this country. That's just the foundation. I'm not.
Because it's important to underline that we've been used to this
impunity.
We didn't even know it was impunity, that it was a bad thing.
Yeah.
We thought it was a matter of anything. You know, there was a time of long legs.
Yeah, people can even boast about it. Nothing can happen to me. You know. So people now, if for the first time, and I'm not against the Senate president, I pray that he gets through and be found to be innocent, if indeed he is innocent, and I pray that other people who are in similar conditions, if they have been wrongly accused, should be let go. But the point that we're trying to say is that due process and rule of law should take place. And if people are found, exactly from the top, people that are guilty are found to be corrupt and they are dealt with, immediately people will get into their psyche that if you do this thing, they will get you. And if they get you, you are going in for it.
And that is where we want to be, because that is what this government promised before arriving.
That's right.
That's right. There will be changes.
That's right.
Unfortunately, we've run completely out of time, but I'm delighted at your help in analyzing it, especially from the hardcore legal aspects of it, Malaki Ogumadu.
Thank you very much. Always my pleasure.
National President of CDHR. And Dr. Amadeli Boyo, thank you very much, Public Affairs Analyst as well. I'm Yori Folarin. Bye-bye for now.